Number 8, protect your assets when you are gone. How do you do that? Can you do that through a revocable living trust? Not for your spouse, you can't. Maybe for your kids, but not for your spouse. So I'm the founder of Elder Law Group. We know government benefits. We know long-term care costs. We work with all generations, but the people who are particularly concerned about protecting their assets for their spouse, especially, are usually retirees. Why are they so concerned? Because of long-term care costs, because we all know long-term care is expensive. It's not $5,000 a month typically. It's at least between $5,000 and $10,000, if not $10,000 to $15,000. I said per month. So it doesn't take a whole lot of time that somebody is in long-term care that you can see the assets deplete and then they're gone. How do you make sure that that doesn't happen? How do you make sure that you leave money for your spouse and you leave money for your spouse, even if they're in long-term care, and still have the state pay for their care? There is a way to do that. How do you do it? You need a will with asset protection and asset protection trust. It's also called a supplemental needs trust. And you need a probate. Didn't I just say avoid probate? I said avoid probate if there is no benefit. But if there is a benefit, then probate might be the smartest thing for you to do. Let me give you an example. Let's say you have a couple and the first spouse dies and they want to make sure that their surviving spouse, let's say the husband dies, surviving spouse has Alzheimer's. She's going to need care. Let's say this couple has $800,000 in total assets. Well, if they did a revocable living trust, or if they didn't see an elder law attorney, they are going to end up with a plan where all of that $800,000 is going to be spent down before the surviving spouse with Alzheimer's is going to get state benefits to pay for her care. Contrast that to, you go to an elder law attorney, they do a will for the husband and the wife. The husband dies, the will has an asset protection trust in it. After he has died, his share of this $800,000 estate or $400,000 is going to pay to an asset protection supplemental needs trust for the surviving spouse. $400,000, half of his estate. Yes, his wife is going to need care, and she likely will spend down her money unless there's a Medicaid strategy in between, but let's put that aside for now. I really don't want to complicate it too much. Let's say that she spends down her $400,000. Okay. Does she need to spend down the $400,000 that is in this trust that her husband left for her? No. She can have $400,000, whereas the person that doesn't have this plan can have only $2,000. That's it in countable assets. She can have $400,000. Why? Because it's not considered countable, because it's in the right kind of trust that the state honors. So through having a probate and having the right will with asset protection, that surviving spouse will have her care paid for by the state, yet have $400,000 in trust to make her care that much better, to supplement her needs, whatever. And then at the end of her life, it will go wherever they wanted it to go. So this couple's assets will never be depleted. They will never run out of money because they had this type of trust and they had a probate. That is one of the main tools that we have as an elder law firm to protect assets and ensure that you will leave your spouse money and they will never become impoverished.